Well, greetings, everyone. My name is Brian Ward, and today we're going to discuss a case that's before the Supreme Court of the United States that will fundamentally impact the lives of this entire nation. The case comes out of the Ninth Circuit Court of Appeals from the state of Oregon, in which the circuit court held that if a political actor, a governor, mayor, fire chief, etc., believes that an experimental drug, a drug that has not been approved by the FDA for its safety or efficacy, that if they believe that that drug will protect public health, then they then have the authority to issue a legal requirement of individuals to inject that drug into their body, and listen to this, while also requiring that individual to waive their constitutional guarantees to sue if the drug injures them or its administration or any activities casually connected to that drug. Now, what the Ninth Circuit specifically held is that they can condition public benefits on that requirement. Public benefits such as public employment, if you're a firefighter, police officer, EMT, school teacher, etc., or upon a state license. If you are a healthcare worker, a realtor, an insurance agent, a lawyer, etc., you too can be compelled by the state to inject these experimental drugs into your body as a condition of enjoying these public benefits. And that would also include unemployment assistance or going to public education, particularly post-secondary education at the university level. So the plaintiffs have asked the Supreme Court to answer two basic questions on behalf of the nation. Number one, can a political actor, governor, mayor, etc., mandate an individual to inject an experimental drug, also known as an investigational drug, into their body, and/or to accept the administration of a drug that has been designated underneath the PrEP Act as a cover countermeasure as a condition of enjoying these wonderful public benefits that we receive as the right of citizenship. Now, you have the explicit right to refuse both, and I'm going to take you through both of these real quickly so that you'll understand how your lives will or will not be impacted according to what the Supreme Court does with this case. First of all, what is an investigational drug? It's a drug that has not been approved by the FDA for its safety or health. It's a drug that can be manufactured in the back lab of any pharmaceutical company. It can contain contaminants, and it can have multiple variations of formulations and different types of ingredients at different quantity levels. So you will never know what's injected into your body. If two coworkers go and receive the same named investigational drug, they could receive two distinct formulations. You don't know how your body's going to react to that. An investigational drug is the world's most dangerous drug. Now, a licensed product, by the way, has to be manufactured at a specific named manufacturing plant. It has to be manufactured under very strict purity protocols. It can contain no contaminants whatsoever, and it must always maintain the static formulation. It can never change in strength of any ingredient whatsoever. So with that understanding, by what lawful authority could we claim the explicit right to refuse an investigational drug without incurring a penalty or losing a benefit to which we're otherwise entitled? Well, there are a number of sources of lawful authority that gives us that right underneath the Federal Food, Drug, and Cosmetic Act, the Public Health Services Act, and others that have been developed over the past 80 years. But I want to focus your attention on one lawful source of authority that goes to the heart of this issue. In 1973, Senator Edward Kennedy conducted hearings in the Senate of human rights atrocities where federal authorized or funded medical researchers involving humans with investigational drugs and other biologics and devices and other activities caused massive amounts of irreparable harm in this nation, including death. So Congress reacted in 1974 by passing the National Research Act. This led to the creation of Title 42 of the U.S. Code, Section 289, that explicitly places the executive branch under a ministerial obligation to protect the rights of the American people when they are involved with an investigational drug, biologic devices, or a related research activity. Because of this congressional mandate placed upon the executive branch in the year 2000, the Health and Human Services Agency established what is known as the Federal Wide Assurance Program. This program places any person wanting to use federal funding or federal authority to involve a human with an investigational drug or related activity to ensure that they will obtain the individual's, this is a quote, legally effective informed consent. Now, this is a unique standard that's applicable to unlicensed medical products. or related research activities. And what this means is that the person, when they present you with an opportunity to receive the administration of an unlicensed product, such as an EUA drug, that they will promise that they will never place you under, quote, undue influence, quote, coercion, or, quote, unjustifiable pressures to receive this product. Now, you're probably already asking the question, Brian, are you telling me that this was in place during the COVID-19 pandemic? Absolutely. Since the year 2000, some 30,000 entities have signed this contract because you can't participate in federal funding without this contract. All U.S. states, all major hospitals, all major universities, and some 30,000 other entities hold active federal-wide insurance contracts. Now, on this basis alone, we have the explicit right to refuse. Why? Because it is a duty placed upon the state of California, as an example, with Governor Newsom, to obtain your legally effective informed consent. And if he has to obtain a thing from you, it means Congress has conferred upon you the right to grant or withhold such consent. Now, beyond that, you have the authority under the Federal Food, Drug, and Cosmetic Act and the Public Health Services Act explicitly throughout those different acts to refuse these drugs because they are required to obtain your consent, either orally or in writing. Specifically, under the EUA statute, no one read down the paragraph L that says that the secretary can grant the public access to unlicensed drugs, but only on the condition that he refrains from requiring any person to participate in an activity that he authorizes. Well, one of those activities, America, is the activity of receiving the administration of the products. So he has no authority to require you to take these drugs. Well, under the Supremacy Clause and 80 years of Supreme Court precedent relating to the Food, Drug, and Cosmetic Act, all states are preempted, and all political subdivisions and any political actor are preempted exclusively under the Supremacy Clause from interfering with the federal obligation of the Secretary of ensuring voluntary administration. Now, what's going to shock you is that these cases have arrived to the Supreme Court not because the courts disagree with everything I just told you, but because the courts, these judges, these federal judges at the district level and at the appellate level, they refuse to even acknowledge the existence of the arguments. They would not touch them, they would not acknowledge them, they would not analyze them, and they never would respond to them, even though the defendants didn't dispute any of the allegations. In other words, we have the Ninth Circuit Court of Appeals, along with the Fifth and the Third and the Tenth Circuits, it's all across America, significant judicial corruption, who was informed at the pleading stage for the lawyers out there that the defendant was under a contract of which the defendant didn't dispute, that they could not mandate an EUA product because of the federal-wide insurance program and for other reasons. And yet the Ninth Circuit just overrides the federal government. They override the executive and legislative branches and your rights to claim that Governor Newsom or Governor Inslee can mandate the use of any investigational drug irrespective of the harm it could bring to your life, America. This is an unspeakable evil. Now, there's another argument that's at play here, and this one is even more important to you, and that is the argument that you have the right to refuse a drug that has been designated as a covered countermeasure underneath the PrEP Act. Now, why is this argument relevant? Number one, the PrEP Act inherently waives your right to sue anybody if you're injured by the drug, its administration, or activities casually connected to it. Now, since the founding of our nation, the right to judicial remedy when you are injured is a right that has been embedded in Article 4 of the Immunities and Privileges Clause. The right to access courts when you are injured or deprived of your life, liberty, or property. This right is so fundamental, so ingrained in the Constitution that predates all the way back to 1215 AD when the Magna Carta was created, and it was explicitly discussed in detail during the creation of our Constitution. No person has the authority in America to deprive you of this right. Now, because this fact is true, no governor, mayor, or political actor in America at the executive branch or any state or political subdivision, do they have the right to mandate you to surrender this constitutional guarantee as a condition of enjoying public benefits. Now, because they can't do it directly, the Supreme Court said in 1918 in Bailey v. Alabama, they can't do it indirectly. And that's precisely what they have done. By requiring you to use a PrEP Act, which extinguishes any right to sue if you're injured by the product, they have indirectly achieved the result they could never command directly. So they are waiving your rights through the use of the PrEP Act countermeasure program. That is a strong constitutional argument. And if we don't win this, right, what this means, if we don't win this case, America, what this means is that the enemies of our nation who lived within our borders will have found the blueprint to strip us of all our constitutional guarantees. In fact, the Supreme Court spoke to this very thing. It says that the state may condition the relinquishment of one constitutional right to earn its favor. Then it would manipulate all constitutional rights out of existence. And the Supreme Court has forever opposed such efforts. In fact, the Supreme Court has said that when you waive a constitutional right, it must be knowingly, intelligently, and voluntarily waived, and it can never be the product of intimidation or coercion. So with that understanding, let me just finish by asking you a simple question. Imagine for a moment that for the last 5 to 30 years of your life, you've built a very successful career in your business, in your public employment, in your licensed profession. And a flu season comes about, and your political state actor, a governor, mayor, etc., mandates that you inject an investigational drug into your body, the world's most dangerous drug, where you're going to be required to play Russian roulette with your life. And oh, by the way, the governor says, if the chamber lands on a live round and you are injured irreparably, you must prospectively agree now to never sue anybody for that injury, where you will bear the financial and emotional consequences alone for the remainder of your life as a condition today to continue your economic success. Do you believe that this is constitutional, equitable, fair? Do you believe that this is right? Do you believe that this is America? Of course not. Do you know this is the one issue I have never found a single Democrat or liberal or conservative or Republican who disagreed with? No one believes this is right. 100% of the American people believe that we should have the right to live our lives free from this type of governmental intrusion. And so we have arrived at this location only because there are select members of the federal judiciary who are being influenced by external forces to overthrow the republic and overthrow your rights, America. Now, the Supreme Court has awakened. They understand the consequences of the implications of these cases, and a number of other organizations now are waking up, and they're getting ready to file amicus briefs to help further these arguments in the Supreme Court. So I have 3 requests of you. Number 1, share this audio recording. Number 2, if you desire, go to covidpenalty.com and read a paper that I wrote titled Access to Courts. It's a 10-minute read, and it gives you a fairly in-depth understanding of your constitutional right that can never be taken away through a public health mandate, period, ever. And number 3, because of the significant financial cost of getting through all the judicial corruption over the last 3 years. The funds have been completely depleted. And now we find ourselves right on the verge of victory, where the Supreme Court has shown strong interest in 2 petitions involving the same arguments, and there are 2 more about to be filed. So there will be 4 before the Supreme Court arguing the same thing and showing judicial corruption. There needs to be raised at least, at minimum, $20,000 to cover the expenses. So we're looking for 200 people who would donate $100. And I'm asking you to go to covidpenalty.com, click on that donate button, which takes you to Give, Send, Go, and give a donation to fight for not only the firefighters, police officers, surgeons, doctors, nurses, school teachers who were involved, but this case ends this charade for the entire nation. And we're here. It takes hundreds of thousands of dollars and tens of thousands of man-hours to arrive at where this case is at today. So by your small investment today, it would make a significant impact, not only in the lives of these plaintiffs, who are just frontline American heroes, but to protect you and every single person that you love from all future government mandates that are built upon communist desires. I don't know how else to say it, but I'm telling you, we're being assaulted from within. But God always raises up people to fight on your behalf, and such is the case in this endeavor. So I'm asking you to go to covidpenalty.com and donate, and let's win this one on behalf of the entire nation. Thank you for listening. God bless you.